Hello and welcome. You are watching Property Hotline with me, Kavita Krishnan. With us in the studio today is Uday Wavikar. Uday Wavikar is the VP Consumer Court and Bar Association, Maharashtra and Goa. He will be answering all your legal queries related to buying, selling and investing in real estate. Uday, welcome to the show. Let's get our first question. It's coming through email from Fauzia Mohiddin, and Fauzia wants to know whether after entering into a sale agreement for a gated community, can she still negotiate with a developer considering the present demonetization situation? She says that she's finalized a 1500 square feet site at a rate of 3,650 rupees per square foot near Jail Road. This is close to Hosa Road in South Bangalore. She's paid the token amount in September, but the document verification process is still on. So she wants to know whether she can still go ahead and negotiate a better deal. You know, we're getting a lot of these questions, Uday, and that is largely spurred by the fact that people believe that there is a chance that they can get a better deal, that prices could come off a little bit. What would you say?
I always say, and I said on the last program also, the prices will come down, maybe for a temporary phase for certain time, till the water settles down. Because the entire finance of the development industry, where there was a lot of cash component in terms of the investment for development, whatever sectors, I don't want to say at the moment, but a lot of cash component was in, and that has been literally taken away. In fact, 96% India's economy was on cash. That is all taken away. So therefore, there will be definitely panic sales. Again, surgical operations on Benami properties would further get the panic sales in the market, which is already started at the governmental authorities in collector land and other lands also. So she is right. But the question to her is, if she has not, token money is all right. Have you entered a memorandum of understanding with a fixed price, or have you entered a registered agreement? If you would have entered a registered agreement, then there is a difficult to get off that deal. You will have to cancel the deal. But if you have only given a token with an understanding that after all the necessary formalities you will enter, you can still renegotiate.
So essentially you're saying that if you've signed the deal, if you've signed an agreement, you cannot renegotiate.
Sign, yes.
Then you have to cancel the agreement.
You cancel the agreement because it's not registered yet.
Is there any...
Had it been registered, Kavita, then there would have been greater difficulty, because you will have to then go to a court of law and get it cancelled, unless you are mutually agreed to.
Say I've only signed the agreement, Uday. In that case, and if I cancel the agreement, what happens? Could I also stand to forfeit the token that I've already paid the developer? What could be the fallback?
The developer will definitely, depends on what is your agreement with him. Normally there is a memorandum of understanding, and even the memorandum of understanding, the builder can forfeit your money, whatever token given, because you are breaking the promise that you have made him. So therefore, at least that loss you will have. But then you have to weigh down that the money that you have given and the rate that you are getting now, which is better?
Exactly, Fauzia. So what you need to understand here is, like we've been telling constantly on this channel over the past few weeks, that is, after a long time, you have the buyer who's finally in the driver's seat, who can actually drive a negotiation and demand a better deal, especially when it comes to buying a house. So do not lose this opportunity. Use it to your advantage. Go and at least try to have a conversation with the developer. Chances are that the developer might just negotiate and might just give you a better deal. Others, if you have your heart set on the property, you can always continue with the current agreement that you have already entered into. But do remember, like Uday said, it's a call that you need to take, whether the benefit, you need to essentially balance between the loss that you will possibly get if you cancel the agreement. You could have to forfeit that token amount that you've given the developer. That is something that you will need to keep in mind. We have another email query now coming in from Chandrasekhar. He owns a 3 BHK house in Thane East. Now the property, he says, is to be shared between 3 cousins. Apart from this flat, he has another property in Kharghar. He wants to share both the properties. He has no idea how to go ahead. What should he do? 2 different properties, 3 cousins. How can they share it?
The thing is, today we will have to check whose names are there on the agreement, number 1. And I will request him to take a proper lawyer's guidance before doing this, so that it is properly done through a property lawyer. But the procedure is, since he has asked, that he has to make a new agreements altogether and transfer by the agreement. It's called transfer agreement. Transfer deeds you'll have to do. And in this transfer deeds, he has to mention how, including himself, how the joint owners would come. Now, depending on whether they are the first cousins or cousins, if there would be son, daughter, etc., then there is no transfer fee. But for all cousins, they'll have to pay certain stamp duties also. So, he has to take a stamp duty consultant into consideration and then do it, because this is like from one person, it will go to other 4 persons.
Right. And Uday, with the wealth of experience that you have in the legal field, we're talking cousins over here. What would you recommend? Should he go ahead and divide the property, or would he be better off selling the property and dividing the proceeds?
See, question is, how do you divide in 3 cousins? I mean, there is something, unless they say ki one room they'll have and the other room they'll have, that's not possible really physically or practically. What you said is absolutely right, Kavita. They can come to an understanding that we'll sell this property and share the money and take our own share and buy a new property. Unless they want to just do it for investment purpose and keep it in joint name, that can be done. So, therefore, most practical is to share. And again, in such a arrangement, I must say, because they are all relatives, they can be the first choice given to any one of the cousin to buy the property also.
So, Chandrasekhar, that's another option.
Or any
that
2
you
of
can,
them for that matter.
Right, that's another option that you can actually look at. You can offer both your cousins the first, this is actually called the right of first refusal in corporate lingo. What it means is both your cousins get a chance to buy the property first. If not, then you sell it to an outside buyer and you share the proceeds among the 3 of you. We have Rohan now, who's written in through email. He's already purchased a flat. The project consists of 6 blocks and 300 flats. Now, according to the sanction plan, 1 block has received permission for construction up to 10 floors. But the developer has built 17 floors instead. 2 blocks are ready for possession. Will this be legal? Even in the sale deed, he says that the project consists of 6 blocks, of which 1 block has 10 floors. Does the registered deed have any value? Can he get the flat registered? Will this affect his undivided share? Uday?
Too many questions at a point.
Too many questions, but it's a very common
questions. We'll come one by one. See, the first thing that he says is that he has increased the number of floors. Now, the question is, what was his original plan, and then did he modify the plan without consent? In Maharashtra, MOFA is still there. Under Section 7, you are not allowed unless there is a specific consent taken by every flat purchaser to change the plan. It's very, very clear. But the question then is whether he has got an additional approval for the additional floors by the municipality. Anything and everything can happen with the authorities, and therefore, if the plans are sanctioned properly, then maybe you'll have to challenge that petition in the High Court. Otherwise, consumer court would be proper. But thirdly, now he is saying that, what was the third question that he was asking is that in this scenario, what can he do and whether it will be legal?
He wants to know whether the registered deed has any value.
Of course,
whatsoever.
Registered deed.
Can he get this flat registered? How will it impact his undivided share?
Very good question, because registration secures you totally. See, it is like this. If you make an unregistered agreement, it will be impounded by the authorities, because that will be non-payment of the stamp duty and that will be an offence. And therefore, your document can be impounded. There can be 200% penalty on it, which will be tough for you. And it will not be a legal document in civil courts or other courts of law apart from consumer court. So, therefore, registration is a must. Once a document is registered, your agreement is pakka, as they say it. For the simple reason is, if you have to cancel an registered agreement, then you have to go to a court of law, or you have to go to registrar and seek the necessary permissions for consent. So, what is important is registration gives you a lot of sanctity. Everything that is registered has a lot of sanctity. You see, even in case of will, there is a lot of sanctity to a registered will. Birla's case we all know.
So, essentially, you should be registering. If you sign any agreement, ensure that you register that agreement. That goes without saying, that's something that
Kavita, the additional point is, in a registration process, there are photographs given, there is a evidence of both the parties before the registrar. That is a clinching evidence of a deal.
Right. So, essentially, it's the only proof that you have that you are the owner of the property. The title gets transferred in your name legally, and the government has a record that this particular property belongs to you. That is the reason why you need to register the property. Now, the other thing, of course, that you need to keep in mind is that the developer cannot change the plan, cannot alter the approved plan without getting consent from all the buyers. So that is one of the rights that you have as a buyer. You need to know your rights. You can actually take the developer to court and seek compensation. We have another email query from Swati now. Now, Swati says that she booked a flat with a developer last year. She paid the booking amount as well. Now, the developer has given the receipt, but not the allotment letter. Swati wants to know what are her rights to get the allotment letter or get compensation for the interest of 1 year since she's booked the flat. You know, Uday, this is something that a lot of developers have been doing, and this typically occurs during the pre-launch phase when they announce a project. They give you a receipt for the money that you've paid, and that's about it. You're told to come back later.
Where is this booking from?
She doesn't say that.
All right. But because if it is in Maharashtra, we have a MOFA which says that a builder, developer has to register an agreement even if he takes single paisa, any sum, and he cannot take more than 20%. So there is a straight statutory violation of Section 4 of MOFA. Apart from Maharashtra, even in Gujarat there is a GOFA which is the same. Hyderabad there is a similar act still there till the RERA is already, if the RERA comes in, then RERA also says that a registered agreement is mandatory. Therefore, she can definitely seek the indulgence of the consumer court on this topic. That will be fastest for her, or go to a civil court and make the builder register the agreement as per the statutory format of that state, and get her even compensation for the delay, and get the terms and terms very clear, and get the entire transaction regularized.
Right, but also Uday, when in a situation like this, typically all you have is a piece of paper.
Correct.
You just have a receipt saying that you've paid so much amount of money. You don't have a flat number. You have nothing.
You will be surprised. I have got the cases where we have gone right up to the Supreme Court only on the basis of receipt issued by the builders. Or even sometimes receipts are not issued, but the bank proofs where the bank payment is there, that builder has taken it for flat and not entered the agreement. The judgments of the National Commission and Supreme Court as well as the State Commission of Maharashtra are for the consumers only, because there is straight violation of Section 4 of MOFA. And most of the states, the consumer law is for the consumers for protecting the unscrupulous exploitation, because the law says you must register an agreement. Even allotment letter is considered to be illegal to the extent that there is no stamp duty paid in the city of Mumbai. So therefore, but if you take it as far as consumer is concerned, the allotment letter would be a concluded contract and will be binding on the builder. So both ways it hurts the builder and not the buyers, but the buyers have to be very, very careful. You must insist on a registered agreement. Many a times even buyers do not want to pay stamp duty, and therefore they indulge in such a kind of thing. But in a longer run, you will be a big, big loser.
So a couple of things that we learn over here. First of all, if you're a buyer in the market, ideally you shouldn't be buying in the pre-launch stage. Of course, flats are very cheap at that point in time. Property does come at a very, very attractive price, but you also run the risk of ending up with no documents like this. This is a huge risk that you're taking, one that you need to understand.
Kavita, pre-launch projects, at least in Maharashtra, have been made illegal unless the agreements are registered.
Exactly. They are illegal, and also, of course, once RERA comes in, pre-launch as such will cease to exist and will become illegal. So that is one thing that buyers need to understand. The other thing is, if you pay the developer any money, even if it is just 1 rupee, insist on an agreement. That is your right as a buyer. Insist on an agreement, sign the agreement, and get that agreement registered. That is your only proof that you actually own a property, own a flat in that particular building, and that will really stand you in case you have to go to the court of law. So these are a couple of things that you need to remember. However, like Uday pointed out, there have been judgments in the buyer's favor, even when buyers have gone to court with merely a receipt, which is why you also need to file every scrap of paper that you get from the developer. It could be brochures, it could be receipts. What all is permissible, Uday, in the court of law?
Court of law, what is permissible most is the registered agreement, because that is the best piece of evidence. But in the absence of registered agreement, you must try and pay builder by checks rather than by cash. Even if you pay by cash, see that you get a proper receipt from a builder on a proper letterhead or whatever is receipt book, which should be serially numbered. And checks the bank passbook or where the amount is credited into account of builder should be very well maintained with you. So the correspondence with the builder, including the emails that you have, they really play a major role. See that if a builder does not issue a receipt, you send him an email that I have paid you so much amount today and this is for this purpose. And this is for a booking of this flat at a particular place. That
Be smart,
habit will
play
help
safe,
you a lot.
stop yourself from picking up the phone and talking to the developer. Always correspond over email or write to the developer. That's the best thing.
There are smart investors who do sting operations and also take builders calculating cash photo video shootings, and I have used that in the court of law. But I do not recommend
But
that
that is not something I recommended. We have Charles now who's written us an email. He says that he had a family arrangement 9 years back. Now there are 2 flats and a shop. Within 3 brothers, the shares were distributed, but the agreements made then weren't registered. What should be done now? Do they still hold in court or should he make fresh agreements?
Question is, when was this done? How long back? That is one question. Secondly, are the parties going to be together? They can always make a fresh agreement if there is no complication. And if there is complication, then only you will have to go to the court
Uday,
of
Charles
law.
says it was done 9 years back. Is there a time bar of sorts on agreements that are drawn up to share property?
See, the more than time bar, they will have to think of the stamp duty that is to be paid for registration. Na? Suppose you want to give a effect to an see, first of all, if you have not done an agreement, you have not executed anything. What have you executed? A mere understanding and a contract, oral contract, but there has to be a more to prove that oral contract. If all the parties are agreeable, anything is possible. Then they can draw a backdated agreement also. But the point is, then it will be illegal to the extent that they will have to pay stamp duty, they will have to pay penalties, and then that how backdated agreement, unless that is correctly executed at that time, will be valid. So the best thing is to come to a conclusion and enter on the similar line, enter a fresh agreement, fresh in the sense correct agreement, take a lawyer's help, because ultimately he is going to really save you. We go to a lot of press and pay for everything, but we don't go to a lawyer, and therefore I would advise that better take a technical person with you, advice from him, and do it accordingly. I mean, that is what is required. You can't get yourself treated by any nurse. You go to doctor.
So if you have a legal problem, do get legal counsel. Having said that, you can of course write to us to get your legal queries answered. But
yes, we are there to assist you.
Do remember that you need to go out there and get yourself a lawyer so that the lawyer advises you as to what is the right step to take in your particular case. We have Paritosh Acharya who sent in a question on email now. He says that he got into joint venture with his own property in 2013 with a ratio of 40-60, in which the builder owns 60%. Now he's planning to construct 20 flats, of which 8 will be owned by Paritosh and the other 12 will be shared with the builder. Now out of the 8, he plans to sell 5 flats. Now within the 5 flats he's planning to construct, he has plans to combine and reside in 2 of these flats. He'll be shifting there once the construction is complete. If he intends to sell this property after 2 years, what should he do?
See, first of all, my query is, what he has not said here is whether that joint venture agreement is registered or otherwise. I take it that there is an agreement and it is registered. If it is a registered joint venture agreement, then there is no question, because the sharing is very, very clear in the agreement, unless and until that agreement is cancelled or rejected or some dispute has gone to the court of law. This agreement stands. So if the agreement allows him to sell the property, or if it is silent also, unless otherwise there is anything that he will not sell for 5 years, he will not sell for 2 years, there is such an embargo in the agreement, he can sell it. It is his property. He can choose to sell some, he can choose to not sell some, and it is absolutely free as long as the agreements are properly drawn and registered.
Right, that's your answer there, Paritosh. We have another email question now from Soumya. Now, Soumya says that she wants to know what can be done if a developer is not giving possession as promised in the agreement. Is there any way to cancel the apartment even if the developer does not agree to this?
This is a good question. Most of the consumers face this, and the best way is to go to Consumer Protection Act, Consumer Forum, State Commission, National Commission, or alternatively, you can also go to civil court. You can also file a 420 criminal complaint. But my best advice is most friendly is a consumer court. You don't have a big budget also, you don't require. Around 5,000 rupees, you can file a case, max 5,000 court process fee. Of course, lawyer's fees would be there, and I would recommend that you put a lawyer for proper guidance and proper conduct of a case, but you will get very good fast results. One, A, you can get the compensation in the consumer court. B, you can get the interest. C, you can get the possession of the flat by proper entering of the agreement and registration of agreement. You can also demand for occupation certificate and building completion certificate and registration of society and conveyance to such a registration of society. So you can really ensure.
Uday, we are seeing a lot of cases nowadays where projects, and this is largely rampant in the NCR, though you see enough cases in Mumbai as well, where projects are not being completed.
Exactly.
Now, this is possibly also because the developer A has either run out of money, or the project cost has overrun because approvals have been delayed for a long time. Now, in such a case where the developer genuinely doesn't have the money to complete the project, what can the developer do? And in this case, what can the buyer do then?
See, you are asking both side questions. As far as the buyer is concerned, buyer has every right to get the compensation, because developer is a professional person. He has committed to them by an agreement, and therefore how consumer should suffer for the mistake of a developer, or even sometimes there are motives behind these mistakes. Sometimes there is a lot of siphoning of the money, transfer of the projects, which we have seen in Delhi NCR. So therefore, developer is not a person who is so naive that he genuinely suffers and profit. There are some exceptions. So therefore, consumer courts have come very heavily, and they have given even to the extent of compensation of market value proportionate to what buyer has paid. Now this is one-sided as far as consumer court is concerned. But if you all meet together, and if the project could be taken over by the buyers or some other developer, he can definitely enter into another JV, and then he can promise, and this has happened in many cases, even while the case was running in the consumer court.
You know, this precisely is what I'm asking, because chances are if you ask for compensation and the developer is actually cash strapped, then the developer might just pay you the money and not complete the project.
The question is how much property is got, can you attach it and sell it? Then the question comes is, if he goes to the jail, will you get your money back?
Exactly.
So practically what has happened is the societies has come forward, requested the developer that you give it to somebody else. That somebody else has come in. He said, all right, little money you'll have to share with me because the rates are now different. But by some additional money, I will complete the project. Allow me to sell the other flats in the project if I get extra FSI and TDR. This has been done. Such solutions are there, and today the landmark judgment of Kamla, the Honorable High Court has done this. They have formed a committee and said the developer will pay for development, and the committee is going to take over.
In fact, this Kamla landmark case that we've been that is also going to be our big story tonight at 7 p.m. And Soumya, I would recommend that you tune in and see what has happened. This is a particular case where buyers actually got together, buyers across various projects got together, and they've been fighting constantly for their rights, and that's how they finally got, they are finally on their way to get justice.
But
well,
Kavita, the answer would not be complete.
The
answer would not be complete unless she goes to a consumer court and files the case, because the mitigation can only happen when we move the litigation. Otherwise, builder will not even entertain you.
So that's your answer there, Soumya. Go to court, and before you go to court, there would be other buyers who are stuck like you in the very same project. Get in touch with them. There is strength in numbers, and developers usually listen to buyers when they come together. Get together, get yourself a lawyer, go to court.
And class action petition they can file in consumer court.
That's how you can ask for your rights. We have Praveen who sent in a question now. He says that he booked a flat in Adhiraj Samayama by Adhiraj Constructions in Kharghar, Navi Mumbai. Now, after paying the booking amount of 5 lakh rupees plus taxes, the developer informed him that the locality of the flat has been changed. He was in fact asked to shell out more money towards the new flat. Now, Praveen obviously refused to pay as the developer did not provide the detailed layout of the new flat. Now, the developer is refusing to return the booking amount and is also not responding. What steps should Praveen take to get his money back? The locality has been changed, Uday. What can you do?
This is something absolutely using the people's money for the projects free of charge when you have to pay in the market 36%. And this is what is a typical of these builders to do collection and then exploit the common man. And therefore, silver line to a common man, Supreme Court says, is a Consumer Protection Act here. There is a court in Navi Mumbai, which is a consumer forum. Up to 20 lakhs, he can file a case there. Above 20 lakh price of the flat, he can file in State Commission of Mumbai, or he can go above, that is up to 1 crore. If your flat is above 1 crore, which is less possibility, mostly you will come in State Commission, but if it is above 1 crore, you can file in National Commission, Delhi. The idea is that when you file a case, you can ask for an alternative flat in the same locality that has been given. That is a novel judgment now coming in, that the builder, if he changes the location, either in the new location he has to give a flat at the old rate. He can't increase the rate unilaterally, because once the rate has been fixed in an agreement, builder cannot change an registered agreement, the registered agreements cannot be rewritten. So he has to do, go to his commitment. Or alternatively, he can also ask a proportionate market value so that he can buy another flat and there is no loss to him. Now, this proportionate market value, there is a progressive judgment of National Commission, where it is given on adjudication value of the current rate, not only ready reckoner.
So essentially, Praveen, you can actually go to court and seek for damages. Like Uday said, you can ask for a flat in the same locality that you booked in, because the developer cannot unilaterally change the location of the flat once it has been sold to you. With that, we come to an end of this episode of Property Hotline. Uday Wavikar, thank you very much for coming in, answering all those questions. And we will, of course, help you with answers to all your questions related to real estate. It could be legal issues like we answered today, buying, selling and investing, finance or taxes. Call, write in or personally tweet to me. We'll make sure that the country's biggest experts answer all your questions.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/Magicbricks Now. And don't forget to click the like button. You can also follow us on Twitter at Magicbricks Now. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/Magicbricks Now.